How you doing, Tom?
Doing well, man. Long time no see.
Yeah. What happened with Twitch? Did I miss
Oh,
something?
I've been gone since early March.
Early March.
Yeah, I got so I got banned. It's okay. I'm gonna tell you, it's a little bit of like an uncomfortable story. I screwed up, but like there were people on Prime Show who were talking about like how women shouldn't do porn if they look underage, so they could be like a 22-year-old that looks
Mhm.
16, and they were saying like they shouldn't do porn. I don't know if they were saying like legally or morally or what, but I kept saying like, well, what looks underage isn't a real thing. That's something that you've made up in your head. Like that's that's just like completely subjective, and um all you need is like to just be of age, of consent, and we give you agency to make your own decisions. But then they started like taking it farther and farther, and eventually they started calling it pedo porn. Like if a
Mhm.
girl looks underage, then you're watching pedo porn. And so I kind of said, well, in that case, then I'm pro pedo porn. But I said it
Oh,
from the chat.
from that perspective, from oh, you were
Yes,
in the chat or you
I
were
was in the
speaking?
chat. They were yelling
Oh,
at me, and like, anyways. So yeah, so I said that, and then uh I got
you've been
banned.
banned ever since.
Yeah, perma
Even
banned.
though you weren't even like speaking, you
Hmm?
were in the chat.
Yep.
Okay. Wow. Well, that was an interesting saga. I'm sorry to hear that you're banned. But yeah, happy to talk to you about the Texas abortion ban. Any questions you might have?
Awesome. Okay. So the main issue that I have is like I feel like there's a lot of confusion when it comes to how they say like um you can sue somebody, in like anybody can sue a person who helped another person have an abortion, right? Um
Right.
the it seems as though like I look at this and I feel like there's lots of people pushing narratives with this, and it seems like a lot of misinformation where they are the narrative is like any random person will start suing like Uber drivers and
Mhm.
doctors, and they will get $10,000 because they sued them. And now everyone and their mom is just going to start suing these people. But just because
Mhm.
the law says that they can sue these people doesn't mean that one, everybody's going to want to, because that's going to like cost a lot of money, that's going to be expensive. You're most likely going to lose if there are no damages involved, like if you don't have a stake in the
True.
pregnancy process going through, like you have absolutely no chance of winning anything in this. And so
You're missing a couple of key provisions here.
okay,
So
good.
I'll stop right here. So on the one part, everything you say about whether or not people can sue, you're kind of talking about whether or not they will sue. Everything people are saying about whether they can sue is totally true. Like there's absolutely like almost universal, I would say, standing for any private individual, regardless of their connection to the pregnancy or the woman or the provider or whatever, to be sued. You can't actually sue the pregnant person themselves, but you can sue the provider, anyone who aids or abets, or anyone who intends to provide or aid or abet. So in terms of capability, whatever conventional wisdom is correct that any person can sue any person who violates this law and who is made suable by the law. Though obviously the state government cannot sue because the exclusive remedy is private litigation.
Hmm.
On the question of would they sue, because what's the point? Will they get damages? The law offers automatic minimum statutory damages of $10,000 per abortion, and so that is a humongous incentive for individuals or indeed organizations who are already highly motivated to spend money to stop abortions, to sue any individual who procures an abortion. What's more is the law provides for attorney's fees and costs
Here,
so
real
that
quick,
you,
on the first part,
yeah,
when you say automatic, like they aren't winning this
Minimum.
just because they sued them. Yes, this is minimum if they win the case.
Yeah, they would have to win.
Okay.
But the problem is, as I'll explain later, the point of this law is not necessarily to have tons and tons of litigation. That's not the point of the law. The point of the law is to ban abortion, and effectively it's done that. Why? Because no one wants to take the risk of being sued and paying out crazy damages. The law does other things to make litigation burdensome. There's like an automatic universal venue statute, which says like if you're a resident from Texas suing someone, you can sue them from any county in the state. So you can sue someone and make them come to court all the way out in bumfuck nowhere. It's hard to appeal or to review the law, and if you fail to challenge the law successfully, you have to pay damages. There's a bunch of defenses that are not available for you if you try to claim innocence based on consent of the pregnant person. If you or I should say non-liability, non-culpability, non-liability, really. You can't claim non-liability for what's called non-mutual issue preclusion. That's a kind of doctrine whereby you can think of, like, let's say someone sues you unsuccessfully and you win the case and you can show that your abortion was legal in one case. You can't use that judgment in the next case if someone sues you on the very same abortion you just won on. And so there's a bunch of stuff that makes litigation costly and unattractive for defendants. And for that reason, the law has been successful in shutting down most abortion procedures in the state, which is its real aim.
All right. So I guess, like, full disclosure, like, I'm pro-life. I don't want abortion to be illegal, and I, like, have debates all the time. Like, as a pro-lifer, like, I don't think that we should just move straight to, like, hey, this needs to be illegal. But I do think that, like, we should do things that incentivize people not to have abortions more. But normally the things that I talk about is, like, if the top 3 reasons for having an abortion is, like, not having a significant other, not wanting to lose your job, or not having enough money, then we help women with those 3 things through government or through whatever, to make it to where, like, the main reasons for having abortions were no longer concerns. And then all of a sudden, hopefully the majority, I think that's something like 70% of abortions would hopefully just kind of disappear. In this case, I don't know, I guess, how I feel about this, because I always have conflicting feelings on, like, whether or not a father has some sort of say in the birthing of his own child, and whether or not, like, a mother has signed some sort of, like, social contract with him when she has sex with him, understanding that pregnancy is a possibility. That, like, that she wouldn't just do away with his spawn. And at the same time, I don't want them to have, like, control over her body or be able to tell her she can't have an abortion, right? So these are, like, conflicting feelings that I have. And I feel like this does something to where it says, though, she's still allowed to have an abortion, but there are
Not
incentives.
illegal, right?
Huh?
It's illegal.
Well, when you say it's illegal, they still have abortion clinics. Like, they're still going to have abortion clinics, right?
Those aren't provided. They're not providing the services anymore because they don't want to be sued. So to get an abortion, to have an abortion, you have to get an abortion procedure of some kind.
Mm-hmm.
And if no one is offering them because no one wants to be sued, then the service is, for all intents and purposes, unavailable.
So they would have to, like, go to another state to do it?
Yeah.
Wow.
Go to another state. The one couple caveats.
Mm-hmm.
One is it's unlawful to have that abortion if you don't test for cardiac activity of the fetus. And that is a requirement that you have to test for cardiac activity before you get an abortion. Mm-hmm. Or if you detect any cardiac activity, getting the abortion would be illegal. That's in violation of clear Supreme Court precedent. And so it produces a conflict with Roe v. Wade and Casey. which are the two leading cases on abortion. And so essentially what we have here is a law that has effectively shut down most abortions in the state of Texas. And so that's just the reality of it. What you offering some conflicting, I don't know, philosophical or moral problems really gets to the merits of abortion as a policy. And I don't want you all to think about this case principally as dealing with abortion as a policy. What we should be concerned about and why we should all be in uproar about this decision, this law, and the Texas legislatures is how they're going about doing this. Regardless of what you think about abortion, whether it should be a right recognized by the Supreme Court as found in a substantive privacy right. Little slight digression here, little slight editorial. Those of you who are against vaccine mandates, presumably you think that there's some fundamental right to privacy, that the government can't tell you what things you put in your body. So true of abortion. It's premised on this notion of fundamental privacy. And so you be careful cheering on the merits that Roe v. Wade be overturned, because that might make it much harder for you to strike down any vaccine mandate. Little slight editorial there. But anyway, the reason you should be against it is because what the Texas legislature is trying to do is insulate themselves from judicial review by having these private enforcement schemes where federal standing requirements and federal procedural doctrines make it problematic to challenge in federal court.
Yeah.
And yeah, go ahead.
So I didn't know that that all abortion clinics would then just automatically shut down, because I feel like
they're not like closed necessarily, but like some of them have shut down their services, and like we can't provide you services until this gets overturned.
I feel like there's just such a small chance of anybody actually winning these things to where, and I'm not saying this is a good thing, but I am saying like I feel like abortion clinics would more so just like, I feel like the only people with an actual loss that could actually win in a case like this is somebody like the father, right?
Wait, no, but sorry, it would be easy to win in this case because the law also requires that doctors maintain records of when, how, and essentially maintain records of their tests, and it makes it illegal for them to do the abortion if they detect cardiac activity. And so it would be, they'll have a record of the tests. They'll have records of what the test shows. They'll have record of when the test was. And so essentially the whole point of this law is to ban abortion. If there was never a single case, never a single litigation case involving this law, but no one got abortions, the law would be successful.
Sure.
And so what they're trying to do is, what the Supreme Court essentially has done is for the cases of private litigants now until the United States government has sort of intervened and sued, there would have had to be a confrontation with the law, and there would have had to be someone who takes the law on and someone to get sued before it can be judicially reviewed. So that's where we're at. But the law has been successful in essentially shutting down abortion, which was its purpose, not necessarily to open the floodgates of litigation, though it's going to do that. It's to stop abortion as a procedure, and on that it's been successful.
Okay. So what I'm not understanding though is like, this is the same as any other litigation where you would have to have some sort of damages, right? So why would
the law defines damages as a minimum of $10,000.
Wait, what does that mean?
So statutory damages. So this is why they call it like a bounty hunter system, because the law is saying is, by definition, if you win a case, you are entitled to, at a very minimum, $10,000 for abortion.
I get that. That's what I'm saying though, is that like, normally in order to win, don't you have to have some sort of loss in the case in order to actually win?
Not in this law. And that might be a reason why the law is unconstitutional under Texas constitutional law, because the law has a lot of problems, and it might still be struck down on many different grounds. One of them is that it purports to give standing to any person in the state to sue, but that's an issue typically of, one might think of it as an issue of Texas state law.
But isn't that
And
normal though? Like, can't anyone sue McDonald's for having hot coffee that can burn someone? It's only the person who
normally,
gets burned that's going to win the lawsuit because they have damages.
normally you're right that for a lot of tort suits and for a lot of, a contract claim, you can't bring a contract claim if you aren't a party to the contract, or if you're not a third party beneficiary to the contract. Just like in a tort case, if you're not the person who was hurt, then how can you sue based on it? What I'm telling you is that you're generally correct in these statutory schemes, or in these common law schemes, or in these tort schemes, or in these contract schemes. The people suing are interested parties. And typically you have to prove damages is one of your elements, though not always. Sometimes there are, for instance, a case where there's sometimes statutory damages is copyright cases, where there can be statutory damages, which you can get in lieu of actual damages sometimes. So statutory damages is not something that's totally unheard of, but having to prove damages is not something that's totally unheard of either. Typically, you have to prove damages. But what Texas has done, and which might be illegal under Texas law, is to provide standing for anybody to sue. And so, no, under the law Texas has enacted, you do not need to prove damages to you personally. All you need to prove is that the abortion is illegal, and you're entitled to your automatic statutory damages of $10,000. That's the result of having this universal standing part of the law.
Okay, I'm sorry. I'm still a little confused here. Okay, so like from what I understood, like that just meant that anybody could file a lawsuit, whereas like just like in the McDonald's example, anybody can file a lawsuit against McDonald's. That doesn't mean that it's actually going to go through or that they'll win anything, because unless they were burned by the hot coffee.
Yeah. Let's stop right there. So anyone can file a lawsuit for like anything. And so when I say you can't file a lawsuit, I mean you can't successfully file a lawsuit. So if someone if someone else gets burned by the hot coffee and you sue the McDonald's, you can file that lawsuit. But when I say like quote unquote you can file it, I mean you can legally file it. The coffee case is going to be dismissed right away because you weren't damaged and you can't prove damages at all. Even if you prove that there was negligence, even if you prove that the negligence caused harm, even if you prove all the elements of that tort, you haven't proved damages because you're not a damaged party, and so you'd have you either have no standing or you'd have no damages, right? You couldn't prove a core element of the case. What I'm telling you is that is not the case for this law. This law does not require that you suffer any damage whatsoever. Anybody can sue anyone who violates this law, except for the pregnant person, notwithstanding the fact that they're totally unconnected to it. And they can sue because the law assumes damages of at least $10,000, known as statutory damages. In addition, the court can offer injunctions, which are court orders to like stop procedures or shut businesses down. And they can award attorney's fees and costs to the plaintiff. So there's actually a huge incentive to sue. But the long shot of this is it's not just abortion clinics aren't just going to keep doing abortions and suffering potential lawsuits. They're just going to stop doing the services. That's what the law was intended to do. Right. And that's what's happened. Right. So that's all I'm saying is just because there isn't a huge amount of litigation, you could be like, well, the law doesn't do anything. But no, what's happening is people don't want to be sued. And so they're stopping. If they kept on providing those services, they absolutely would be sued. That's why those parts of the law are important, because otherwise then they would keep providing services. But the fact is that those provisions are there, which makes it very easy to sue. Anyone can sue and they can get a lot of money for it. And so there's a huge incentive to sue. And so the result is people are not going to give those services.
So what's an example of like a statutory standing in this case?
Statutory standing. So what I mean to say is anyone, any person, anyone can sue anyone who violates this law, except for the mother, and the government itself can't sue because the exclusive remedy is private litigation. So what I'm telling you is it's universal standing.
Mm-hmm. Okay.
By and large.
So
in Texas, that could be a problem under Texas law.
Okay. So what you're saying is all I have to do is prove that they did break this law in order to have a win. No, I don't have to have any. It doesn't have to have an effect on me. It doesn't have to have any damages, or I don't have to have any claim damages. I just have to prove that they did break the law, and then that's that.
Yeah, that's one of the reasons. In the Attorney General and the Department of Justice's complaint today, they cite that as one of the reasons for another doctrine that they think that private litigants are really just state actors in this particular case, is because the state is enlisting the help of these people to litigate claims which they have no connection to, and it gives them that power to do that. And that traditionally is an exclusive power of executive officers of the state. And so, yes, absolutely, that is the case, that anyone can sue anyone and they can get the damages, notwithstanding that they have no connection to what's going on. It really is that bad. And it's a way to make an end run around the Constitution, and it's disgusting.
It is, because that was going to be my next question. Is like, everybody keeps saying that this is unconstitutional, but it doesn't seem as though it is. It seems as though they just figured out some sort of slimy way around the Constitution.
No, I think it is unconstitutional, frankly. Well, it's not unconstitutional to have a private enforcement scheme. There's tons of laws that have private enforcement schemes. A lot of anti-discrimination laws give individuals causes of action. That's a private enforcement scheme of some kind. That's not what's unconstitutional. What I believe to be unconstitutional, one, is the substance, the merits, right? Whether or not this ban on abortion is before viability, and that is unconstitutional under Roe and under Casey. Under current precedent on abortion, the law is clearly unconstitutional. And the fact that they tried to insulate themselves from review is the problem.
What was you said Roe versus Casey?
Roe versus Wade is the first case. And Planned Parenthood versus Casey is like the affirming of Roe, and they changed the standard a little bit, but maintained by and large the central holding of Roe.
Okay. So what if instead they didn't make it illegal, but they did make it to where you could sue someone for some sort of damages? Because that was my interpretation when I read it, was that like they're just saying like somebody who has damages, anybody can sue except, but you can't sue the person who, the woman who had the abortion, but like anyone can sue, and then if you have some sort of damages, then you would win, and then the minimum would be at least $10,000, or it could be more if you had, if you were able to claim more damages than that. So if that was the case, that wouldn't be a violation of Roe versus Wade, but it would be like a slimy way around it.
No, I did totally disagree. I think it would absolutely be a violation of Roe v. Wade, because essentially what would happen is, first of all, you don't need to prove any damages whatsoever with this law, because injunctive relief. Suppose that there were no statutory damages. One of the remedies you could get is injunctive relief, and that is a court order. And so presumably you could go to court to tell a doctor to not perform the abortion, or if they keep doing it, they to shut down the abortion clinic because they keep breaking the law or something like that. And so ultimately, the unconstitutionality of this law is the fact that it purports to ban abortion before viability of the fetus, which as we understand current Supreme Court precedent, that is unconstitutional. You can try to frame it as only people connected can sue, only X person can sue, whatever you want to frame it as. It doesn't matter, because it purports to make something illegal, which under current understandings is constitutionally protected. It would be like me saying, if you own a handgun, that's a constitutionally protected right, typically, right? A handgun, in certain circumstances and with reasonable regulation, let's say. If I were to you can sue anyone who possesses a handgun for $10,000, that would be a clearly unconstitutional law. Just like, and if I take away the statutory damages and just say, okay, no damages, but and it has to be someone close to you, but they can get you a court order to take your guns. It wouldn't change anything there. The problem with the law is that it substantively limits a fundamental right or a right recognized by the Supreme Court as deriving from our constitutional framework. And so that's the problem. And no amount of procedural wrangling, it can make it difficult to challenge the law, but it doesn't change the basic unconstitutionality of what it's purporting to do.
Yeah, I mean that's true, but we also have freedom of speech that isn't illegal, yet there are some times when you can sue somebody for saying something that caused you some sort of financial damage, right?
That's different. So what we're talking about here, there are exceptions within the First Amendment that on substance do not count as unconstitutional deprivations of the right to speech. One example is child pornography, which is categorically unprotected by the First Amendment. Another example might be true threats. You threatening someone or harassing someone. Another exception might be, I don't know, state nuclear secrets or something like that. Or who knows, certain kinds of defamation. Those are exceptions recognized within the substance of the First Amendment. And those exceptions, I would say, are part of our understanding of the constitutional right. So our constitutional right includes all those exceptions. What you have to compare is, suppose that there's a law, something like this. You cannot criticize the governor of the state. That would be a law that's clearly unconstitutional under the First Amendment jurisprudence. However, let's suppose that the state passed a law that said a private individual is allowed to sue you for criticizing the governor.
Mm-hmm.
You can't get around the flagrant unconstitutionality of the law through this kind of procedural. You shouldn't be able to, right? Now, the Supreme Court has not definitively decided these procedural merits of these issues, but they have kind of allowed this to fester. And the end run is it's going to be a freaking mess in the near future. And I don't think it's possible that this kind of thing is going to be able to stand. So we have to have mechanisms. Go ahead.
So there are distinctions for things like defamation or something like that, to where criticizing the governor still could be sued, but it's actually written into the Constitution.
So all I'm saying is, you pointing to exceptions within our constitutional framework, those are exceptions that are substantive exceptions. And what you have to compare to try to have an analogy here is not to focus on the exceptions, but to focus on something that's blatantly unconstitutional and try to use a private enforcement scheme to render that outcome. And so abortion, for instance, has plenty of exceptions. You can ban abortion after viability. But that's part of the substantive standard. What the Texas law is purporting to do is in violation of the substantive standard. And that is clear. Mm-hmm. And what I suggest is that the Supreme Court and the federal courts should not allow these kinds of nefarious private enforcement schemes that purport to immunize themselves from review to be allowed. I mean, it's going to chill speech. It's going to chill constitutionally protected activities. It's a big problem.
Okay. Yeah, I wasn't saying that just because there's exceptions, then it's okay. I was asking if defamation is actually written into the Constitution as an exception, or if it's just something that we say, well, there are possible damages in this case, so we allow people to get sued for that sort of thing.
Yeah, no. Typically, the Constitution is a very short document. It doesn't lay out all of its exceptions and its doctrine. We must never forget that the Supreme Court is expounding upon a constitution and not a statutory code. And so what this means is we have court cases and opinions which help us narrow and articulate workable standards to order our lives. And somewhere along the line, right, we recognize that prior to adoption of the First Amendment, which, by the way, didn't even usually apply to the states initially, that there are exceptions, that the First Amendment was never, even though you're not supposed to abridge freedom of speech, not always, right? You can ban child pornography. Same thing with Same reason why, no right is absolute under our constitutional framework. And the fact that these exceptions are not spelled out does not really matter. Whether if they were spelled out, then it would be like clear and decisive, but courts are forced to make tough calls and interpret things as a judge is going to do. And so to answer your question, no, it's not explicitly provided for in the First Amendment. The First Amendment merely says Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech, or of the press or of the people peacefully to assemble and petition their government for a redress of grievances. That's all it says. It doesn't say, and also we have this carve out called child pornography, and also we have this carve out called, right? So that's what I'm trying to get at.
Yeah, I guess the reason, and I don't mean to harp on this one point for too long, just trying to understand it a little bit better. Like, the reason I'm asking that is because when I ask, like, if they hadn't made it illegal, but instead had just said you can sue people if you have damages from them getting an abortion.
No, right? It's the same thing. They don't have to say it's like technically illegal. Suppose that someone said like, "Oh, it's totally legal to criticize the president, but anyone can sue you for $1 billion if you do that." But it's legal. See, that itself is an infringement of the First Amendment. It favors some speech over others. It penalizes speech based on its content, right? It's a content non-neutral infringement or government restriction, even though it's enforced through private individuals. It's a prior restraint in some respect on the use of speech, and that would be struck down almost certainly. Notwithstanding the fact that it's not explicitly stated as "quote unquote" illegal.
Do you have my chat pulled up by chance?
Yeah, I think so. Your YouTube on the side. Yep.
So the some Corlix asked a question, and I don't understand. But he said, Pisco, does it depend on how the law is written?
Does what depend on how it's written?
That's what I'm asking.
Yeah. I think we were talking about shit. Yeah, I don't know. How it's written, how this law was written very much mattered.
Like all laws depend on how they are written.
Yeah.
So
yeah. But the reviewability of the law certainly, because the law literally says no government actor shall be able to enforce this law. And so that was relevant to whether or not it could have been reviewed in court. And the Supreme Court seemed to decide that in all likelihood it could not, or that there were at least serious issues with considering it in the federal courts. And basically the problem is you have to wait until the law is enforced before you can sue. And that is a big problem if that's the state of the law, because that means that states can do all sorts of shit, and not until the injury is felt, not until people's constitutional rights have been suppressed, only then at that point would you have the opportunity to sue. And that's not how things have worked in our country. If there's blatant potential violations of the Constitution, our courts have been instruments to protect those rights, and to issue injunctions or stays on those actions until we determined whether or not the particular government action was violative of constitutional rights. And that's how it ought to be. And this is a big problem.
Okay, he said, does the law depend on, does why the law is different from other cases that require standing depend on how the law is written?
Yeah. Yes. So a couple things. One is, do not confuse federal standing requirements with like standing in the context of state courts or some kind of, I don't know, standing requirement that's embedded into the element of whatever claim you're talking about. Standing for the federal courts is kind of like, how do we even review this law in the first place? How are you in the federal courts in the first place? That is like, can you show an injury? Blah, 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 blah. That's another analysis. That's why the court didn't address the merits of this case, was because of federal standing doctrine. What's confusing is the law itself also provides like purely citizen standing to anyone to sue anyone else on the basis of the law. So the mechanics of the law say that anyone can sue anyone. And so there's kind of two standing discussions. One is who has standing to challenge this law, and the other question is like who using this law has standing to sue an abortion provider, and the answer is everybody except for the government, right? They're kind of two distinct issues. And to answer your question, the reason why this is different, so this, like, usually any kind of law that you could think of, typically it's either going to be explicit or it's going to be assumed that the people who sue are the people who are damaged. And in fact, a lot of states would probably require that as a state standing requirement, and Texas might even do that, and that's why this law itself might be invalidated. And so typically in like tort claims, you can't sue unless you were hurt, or a contract claim, you can't sue unless you were hurt, or any of those kinds of claims, right? You can't sue unless you're hurt. That's the kind of default assumption, I would say. It's probably explicitly written some places. It's definitely a common law understanding, but laws can write whatever they want. And so this law explicitly states that anyone can sue anyone else. And so it really matters that they wrote that in there. If they didn't write that in there, then the courts would have to interpret it. And I'm sure courts would interpret it to be that you'd have to have some kind of damage or some kind of relation. But that's not what the law says. And so it does matter that it was written there in the law. I hope that answers the question.
Does anybody else have any other questions? It's different because any Bob, Sally, Joe, Peepaw can sue Rando for getting an abortion, even if the person is unrelated. So that's the part that's just really strange to me. That's super weird. Like,
you wouldn't want it with any other constitutional right? So if someone was like,
or anything at all, all.
But think about it like this. So suppose that you were like, there was a law that said you can sue any school that allows black children to be in the same classroom as white children, right? That's unconstitutional at least for state schools, because of the Equal Protection Clause. And we know that from Brown versus Board of Education, right? Mm-hmm. But it would seem ridiculous that you could avoid constitutional judicial review just by having these private enforcement schemes. Not that private enforcement schemes are always unjust, but they shouldn't insulate you from judicial review if what's at stake is a federal constitutional right, and what looks like an obvious intent from the part of the legislature to try to suppress those clearly recognized constitutional rights, regardless of what you think about Roe v. Wade on the merits, right? That's a separate conversation.
Right.
If you disagree with Roe v. Wade on the merits and you think Roe v. Wade should be overturned, then fine, let Texas have this law and review it.
Is it Roe v. Wade?
Ban it. Go ahead.
I'm sorry, go ahead and finish.
Or ban abortion, like Mississippi did, and try to get the Supreme Court to listen to you. That's different than why, like, obviously, I'm also pissed that the court seems to be considering overturning Roe v. Wade. It's stupid. We have stare decisis for a reason. So, Roe v. Wade has been affirmed numerous times. It's ridiculous to me that the court is even considering it. But suppose that I'm like, okay, it should. You want it to be reconsidered. Then at the very least, just pass an abortion ban, a regular one, and go through the courts like Mississippi did, or have this Texas law be reviewable. But the status quo of not allowing this obviously unconstitutional law to be challenged and reviewed is patently absurd.
From what I understood, Roe v. Wade was already changed. Like, it's not even the precedent anymore because it was a privacy, I can't think of the word, like conclusion that they came to after Roe v. Wade, and then they changed it to a bodily autonomy conclusion instead, or protection, right?
I would say that the big change has to do with the substantive standard. So Roe v. Wade implied at the very least that there was to be the highest tier of constitutional review for a law known as strict scrutiny. We're getting in the weeds here.
Yeah.
So basically, when there's a fundamental right at issue, typically the standard which is applied is like a high standard to see whether the law is justified. No law is absolute, right? No constitutional provision, no fundamental right is absolute. You can take away people's guns if they're ex-felons, if they have mental health problems.
Right.
You may be able to prevent nukes from getting into people's hands for compelling government interests. And so nothing is absolute. Even when it says the right to bear arms shall not be infringed, no one thinks it means absolutely. There's some amount of purpose, some amount of government interest, which will allow the government to, notwithstanding the fact that it says shall not infringe, to prevent you from getting certain guns. So the highest form of that scrutiny you might think of as strict scrutiny. And that was kind of what was implied by Roe v. Wade. Casey understood the right to privacy that recognized by Roe v. Wade as also existing, but just applied kind of a different standard called the undue burden standard to it. And so you're correct. And then it got away from the trimester framework of Roe v. Wade and adopted explicitly the viability standard. And so that kind of is where they were at and changing it. So yes, that's what it's about. Typically, it's not necessarily bodily autonomy, even though that's like typically an argument in abortion cases. Typically sort of like the right as understood is a privacy right. Maybe it has to do with bodily autonomy. Maybe privacy and bodily autonomy are closer than we think, but the canonical understanding of that right is deriving from some kind of privacy interest understood in the 14th Amendment.
And then Sassafras asked, like, what are we doing now to challenge this? Like, what's the next step in the process?
The next step is the law is still being challenged in Texas by private litigants on all sorts of grounds. And the Supreme Court left it in a weird place. And so there are probably going to be efforts to challenge the law on its own terms. And so that means someone has to face down the law and someone has to break the law, probably, to challenge it. But and they're also probably going to sue in state court, where they're not going to be limited necessarily by the standing doctrine of the federal courts. And so there's probably state challenge. I know there are state challenges going on right now. There's probably continuing federal challenges in Texas from private litigants. But today we heard the Justice Department is suing the state of Texas, and I think that could be a case with legs on it. And what's great about that is the United States government doesn't have to worry about a lot of the sovereign immunity problems with the private litigants, because the United States government is allowed to sue states directly. And so a lot of the problems which reared their heads in the state courts is not necessarily a problem for the United States government. But they still have to find standing of their own. Right. They have to have their own interests. And so that is still up in the air whether they'll meet that burden. But if they do, they'll be able to challenge the law specifically. So this law is going to be challenged one way or another. The merits hopefully are going to be dealt with, although the law might be struck down on Texas constitutional grounds long before it's dealt with on Roe v. Wade grounds.
But they haven't actually filed yet, right?
They filed. Yes, the Department of Justice has recently filed a complaint today. It came out today, so they sued Texas today.
Wow. Okay.
Yeah, man.
I appreciate you coming. Yeah, like my main confusion, was just like the way it's written, the way I kept explaining it to my audience is like, look, like anybody can always sue. Like that's always a thing. So like I had the McDonald's example, or like where it's not necessarily McDonald's didn't break the law necessarily, but somebody had damages, and so they just have to prove that there are some sort of damages regardless of whether or not the other person broke the law, and they're able to get some sort of relief through a lawsuit. And then like the same thing with like, people, the wife's family sued O.J. Simpson. Like he didn't even get convicted of committing the crime, but they still sued him and won, and had damages and were able to win a lawsuit because like they had a loss in the matter. And so the way I read it like seemed as though it was the same kind of thing, but I didn't understand why it said it's against the law, because that's what confused me. So that makes a lot more sense. I appreciate you clearing that up.
It's really bad. Yeah, it's really bad. It's really broad. It lets anybody sue, really, except for the government. But glad to come on and chat with you, buddy. Hope you continue investigating, and maybe Twitch will undo your ban at some point if it was unjustified.
Awesome, man. Appreciate it.
Yeah, no problem. Have a good one. All right.
You too. Later.